What are the biggest mistakes or the biggest risks associated with self-representation during a divorce? It's a terrific question. My name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family issues here in Michigan. And today, we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. What are the risks associated with representing yourself? Well, it's interesting. I have two expressions that I use all the time, two analogies that I give to people why they should not do this. Because, there are certain areas of the law where self-representation is allowed. Divorce is one of them. If you want to represent yourself, you certainly can do that. But I liken it to a person who has a toothache. And I always say, if your tooth hurts, you can go in the garage, grab a wrench, pull it out. And you can do that. But you know what? You should probably go to a dentist. Why? Because he knows what he's doing. And you don't. I often say that as it relates to divorce. Divorce is the same thing. You can do it, but you're not going to know what you're doing. I often liken it to driving down I-75 with a blindfold on. You might get to where you want to go. You might do that. But odds are you're going to kill a bunch of people along the way, and there's going to be carnage, and there's going to be a wreck, and you'll never get to where you want to be. And that's what representing yourself is like. I have often found myself using those two analogies. The question is why, though? Why is it that way? Well, let me get into the why behind those analogies. Well, number one, if you are knowledgeable and experienced and know what the rights are and know what to ask for and know what to analyze and bargain for in your divorce, you will likely cover those things. The problem is that people who are not lawyers, who are not educated in the way of legal matters, who do not know the lay of the land of divorce, they don't even know what to ask for. How are they going to know if they're giving up something they don't even know they have a right to? I cannot tell you how many times people have called me up and said, I don't care. I'll give him everything. I just want my name back. You hear that a lot. I just want my maiden name back. But then I sit down with them and I tell them, well, you're entitled to one half the value of the house. You're entitled to continuation of the health insurance under the COBRA rules. You're entitled to take certain deductions with respect to the children. You're entitled to equity in the house. When I start telling them, all of a sudden their maiden name is not enough for them to take away. All of a sudden they want this and they want that and they want this. And ironically, sometimes they want something that is beyond what we think is reasonable. I will say to them, wait a minute. 5 months ago, all you want your name back. Now I'm telling you what you should get, and you're arguing with me about it. You don't think that that's enough? Before you didn't want anything. The point is, though, people, if they don't know what the rules are, they don't know what their rights are, how are they supposed to know what to ask? You represent yourself. You're not even going to know what to ask. You're going to leave a lot of money on the table, a lot of rights, a lot of benefits. You're going to leave them on the table because you won't even know to look for them. That's one big danger. Another big danger is you could lose your case for procedural reasons. You could lose your case and not get an opportunity to be heard and not get an opportunity to state why you feel you should have the custody of your children. You won't be able to do that because you failed to file something on time. You failed to argue a certain thing. You failed to give certain notices. You gave a notice. You failed to provide a proof of service. You failed to do procedural things that the court rules require. Lawyers know these things. Lawyers or they're supposed to know these things, and they follow the court rules. They are adept at doing that. The good ones know how to do it. The good ones follow the rules, and therefore you get your opportunity. The problem with representing yourself, if you're not familiar with the rules, if you don't have a working knowledge of the Michigan court rules, of the Michigan rules of evidence, if you don't have a knowledge of the UCCJEA, if it's relevant to your case, you're just not going to know, and you might risk losing your case, not on the substance, not because you were the wrong choice, not because you were the bad parent. You'll lose to the bad parent because they know what they're doing and you don't. That's a very big gamble that you're taking to save a few dollars. So you got to watch out for that. The opposing lawyer will certainly take advantage of you. The opposing lawyer, when he sees you're not represented by counsel, will start bombarding you with discovery requests and time-sensitive things that you're not going to know about. And you're going to blow it. And you're not going to answer them right. You're going to tell the court, well, I didn't file an answer, but I figured I'd come in and I'm available to give answers. That's not how it works. The court has rules, local rules, court rules that it follows. When one person knows them and the other one doesn't, that's a tremendous disadvantage. You don't know the rules. You don't know the exceptions to the rules. And that is a real problem. What I'm trying to say is, you're far more likely to get a bad result in your case if you are disadvantaged by the fact that you don't have an attorney. That's really the reason why it's like driving with a blindfold on. That's why it's pulling your tooth out with a wrench, because the likelihood of a good result is dramatically increased when you're represented by somebody and there's an even playing field. When the playing field is not even, you're not likely to come out ahead in that deal, okay? So, some people say, well, I can't afford it. Well, it's strange. If the other side can afford it, you can probably afford it. And if he's got the money and you don't, then you file a motion for attorney fees so that you can hire a lawyer. You're allowed to do that. Oh, I am? Yeah, it's another thing you didn't know. Why? Because you're not a lawyer. Don't you see? The problem is that in order to know what the rules are, you probably have to have a professional handle it. And the professional can help you get money to hire that professional, but you may not even know that. Why? Because you're not a professional. So all I'm saying is there are certain cases that you might be able to get away with. You got 2 kids, 21 years old. They've been married for 8 months. They have no children. They have no assets. They have no liabilities. They got 2 bean bags that they got to split between them. They can probably go without lawyers. Anything else, any assets, a marriage of 5 or 10 years, a marriage where there's property, a marriage where there's children, a marriage where there's debt, anything all, you know what? You're going to have a lawyer handle that. And you know what? It is going to cost you some money. There's no question about it. Just like when you have a medical problem and you got to see a cardiologist. That costs money too. And on a simpler level, when a pipe breaks in your house, you got to call a plumber. And guess what? That costs you money too. And you want to say, I'm not paying it. He was here for 15 minutes and he charged me $300. Well, you know what? That $300 is what caused your house to not be flooded. So you have to keep this, in mind in terms of it's not can you afford to get a lawyer? Can you afford to do this without one? The answer is in most cases probably going to be no. So therefore, bite the bullet and find a way to hire yourself competent representation that can help you. If you have any questions about that, reach out. We'll be glad to help you out.
248-588-3333. 248-588-3333.